straight ahead on Law&Crime Daily.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million.
For the first time since the verdicts were read, defendant Amber Heard speaks out. And
did Ms. Redlick tell you why she did not call 911?
She just said she couldn't find her phone due to all the blood and stuff on the floor.
Child Protective Services investigators take the stand as a Florida woman is tried for the murder of her husband. Plus, hear from both sides as convicted killer Alan Wade faces the death penalty.
Some evil acts can only be sufficiently punished by the ultimate punishment.
And while some crimes do deserve the death penalty, some defendants do not.
And later, a Michigan police officer is charged in the death of Patrick Lyoya. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. It's been nearly 2 weeks since jurors reached their verdicts in the Johnny Depp versus Amber Heard trial. For the first time since then, we're hearing from defendant Amber Heard. Millions of viewers watched the verdict handed down right here on Law&Crime Network and the gavel-to-gavel coverage of the trial before that. Actor Depp sued ex-wife Amber Heard for $50 million, arguing Heard defamed him in her 2018 Washington Post op-ed about domestic abuse. Heard fired back with a $100 million countersuit, doubling down on her abuse claims. After weeks of testimony, including from both Depp and Heard, the jury awarded Depp $10 million in compensatory damages and $5 million in punitive damages. Heard also won part of her countersuit when she was awarded $2 million in compensatory damages and nothing for punitive damages over comments made by Depp's attorney, Adam Waldman. For the first time since the verdict, Heard sat down with NBC News' Savannah Guthrie for an exclusive interview. Heard told Guthrie she does not blame the jurors for the verdict.
I don't care what one thinks about me or what judgments you want to make about what happened in the privacy of my own home and my marriage behind closed doors. I don't presume the average person should know those things, and so I don't take it personally. But even somebody who is sure I'm deserving of all this hate and vitriol, even if you think that I'm lying, you still couldn't look me in the eye and tell me that you think on social media there's been a fair representation. You cannot tell me that you think that this has been fair.
Of course, we also touched on what happened in court and what the jury decided. There's no polite way to say it. The jury looked at the evidence you presented. They listened to your testimony, and they did not believe you. They thought you were lying.
How could, I'll put it this way, how could they make a judgment? How could they not come to that conclusion? They had sat in those seats and heard over 3 weeks of nonstop, relentless testimony from paid employees and towards the end of the trial, randos, as I say.
So you don't blame the jury?
I don't blame them. It wasn't, I don't blame them. I actually understand he's a beloved character and people feel they know him. He's a fantastic actor.
Their job is to not be dazzled by that. Their job is to look at the facts and the evidence. And they did not believe your testimony or your evidence.
Again, how could they, after listening to 3.5 weeks of testimony about how I was a non-credible person, not to believe a word that came out of my mouth?
We're going to have more of our exclusive interview with Amber Heard first on Today, tomorrow and Wednesday morning. It's a wide-ranging sit-down. And then we'll have the conversation on a special Dateline this Friday night, hour-long, 8/7 Central.
Looking forward to that.
The interview will air on NBC News' Today, Tuesday, June 14th, and Wednesday, June 15th. After that, more on the sit-down interview will air on Friday, June 17th, at 8 p.m. Eastern on Dateline. Joining us today is co-host Terry Austin and trial attorney Janine Atian. Janine, the trial is done. Amber Heard owes Depp, $10.35 million? Could Heard be doing these interviews just as a way to win in the court of public opinion because she lost at trial?
Absolutely. And, you know, she comes across much more likable during this interview than she did when she was testifying on the stand. The other thing that I think is important is that, you know, Johnny Depp's attorneys have alluded to the fact that he may not enforce this judgment. And so maybe she's trying to appeal to him. She uses certain words like rando. She talks about how he's a fantastic actor. She could be being facetious, or she could be kind of like throwing out an olive branch. So I think that she could be trying to win in the public opinion, but also she could be trying to get away from this judgment.
Yeah, we'll see how that plays out, especially as, well, one or both of their careers got to either be taking off or stopping at this point. But Terry, you watched the trial gavel to gavel more than probably anyone else. And you've been on Team Depp pretty firmly for a while. Your reaction to Heard's interview?
You know, I did begin with an open mind, but I've got to say, Brian, just listening to all of her testimony, you have to come to the conclusion that she's lying. She lied about why she wrote that article. She lied about the fact that it was about him, and she even admitted that later on the stand. She said that she had all of these injuries. Those turned out to be lies. She lied about sending the video to TMZ. So, and, you know, she also lied about the $7 million divorce settlement that she gave it to charity. So I think she's trying to blame someone. She's not taking responsibility. And while she's not blaming the jury, she is saying, look, he had all of this evidence, paid people who came in. So I think it's a public relations stunt. And I think she's trying to absolve herself of any responsibility.
Yeah, she's basically saying that all of Johnny Depp's witnesses perjured themselves, that they're paid and they lied, which is an interesting argument. Let's see if there's a lawsuit that follows those accusations, though. Thank you both. Still ahead on Law and Crime Daily, opening statements are presented in the penalty phase of convicted killer Alan Wade. But first, a third story enters the narrative as accused husband killer Danielle Redlick stands trial. Welcome back to Law and Crime Daily. Testimony continued into day 3, Monday, in the Florida trial of Danielle Redlick, a woman accused of stabbing her husband to death. Redlick claims she killed her husband, Michael Redlick, in self-defense when she stabbed him in their Winter Park home in 2019. The two had been married for nearly 20 years and had 2 children together. Danielle's defense attorney said their relationship had a history of abuse and cheating, and the couple had even filed for divorce by the time of Michael's death in January 2019. 911 calls revealed Danielle initially told dispatchers that Michael had stabbed himself and had had a heart attack. Investigators say Danielle waited several hours to call for help, and cell phone records show she spent time on dating apps before calling 911. Danielle is charged with second-degree murder and evidence tampering and could spend life in prison if convicted. On Monday, Child Protective Services investigator Taylor Tucker took the stand. She was assigned to the case the day after Michael was killed. She told the jury about the different story Danielle told about what happened the night Michael died.
Did she share with you what she saw Michael do with the knife next?
She just stated that he ended up taking it out of her hand and then kind of making like a stabbing motion towards himself.
Did she stay in the room or go anywhere else?
She left and went to the bathroom.
What does she say happens next after things went quiet?
She just opened up the bathroom door and then went out. Like she just saw a trail of blood from the bathroom to the living room, and she just followed the trail of blood to the living room.
What did Miss Redlick say that she did when she followed that trail of blood?
She went to see if he was breathing.
Okay. Did she do anything to try to help him?
Yes.
What did she say she did?
Tried to do CPR.
Did Miss Redlick tell you why she did not call 911?
She just said she couldn't find her phone due to all the blood and stuff on the floor.
All right, Terry, based on this testimony, is Danielle Redlick's story credible? And moreover, will the jurors believe it?
Her story is not credible, Brian, and I don't think the jury is buying it. Listen, we have multiple versions of this. First, she tells 911 he had a heart attack, and then he stabbed himself, and then she says he was there with the knife. She saw the knife, and then he made these motions. She went to the bathroom. Then there's another version of that story where she's in the shower and, she comes out and he's stabbed to death. So I think the jury knows that she did it, and now she's claiming self-defense. So they're going to have to figure out what really happened based on all of this evidence and the different stories that the witnesses are telling. And they're going to realize that, she just made up stories as she went along.
Yeah, different stories. And Janine, based on the opening and how the defense are arguing the case, it seems to me, at least, that Redlick has to take the stand to explain the changing stories or self-defense. How do you think she'll survive on cross-examination?
Well, it's going to remain to be seen, but she absolutely has to take the stand because she's had all of these differing stories. She's lied time and time again. But the other thing is her lies are blatant. She calls 911 when she finally does, and she says he had a heart attack. They're going to come to a house filled with blood. So the idea that these are such incredible lies, it may be that when she gets on the stand and she explains, remember, this was her stepfather. There's a history of a volatile relationship. The defense opening says that he was authoritative with her. She may be able to, show that she lied because she was scared. And then remember, her daughter testified today. We didn't get to see it, but she said her father was drinking, that they fought a lot. She did say her mother was oftentimes the instigator. But again, once this woman gets on the stand, we'll have a better understanding. And until she does, we don't know.
Absolutely. We'll see how that plays out, but we'll definitely be watching here, gavel to gavel, for that testimony if and, as I think, when she takes a stand. And switching coast to California as attorneys prepare to present opening statements in the Eric Holder trial in Los Angeles Tuesday. Holder is a man accused of killing rapper Nipsey Hussle. After 3 years of delays, defendant Eric Holder is facing a jury for the first time on charges of first-degree murder, attempted murder, and assault with a deadly weapon. Holder was arrested in April 2019, less than a week after he allegedly shot and killed Nipsey Hussle in front of the rapper's Marathon clothing store. Police say a dispute broke out between the two men when Hussle accused Holder of being a snitch. Investigators say Holder left the store and then returned with 2 firearms. A medical examiner found Hussle was shot at least 10 times, with the bullets piercing his lungs and severing his spinal cord. The judge has ruled there will be limited media coverage allowed, as witness testimony will not be broadcast. Opening statements are expected to be presented Tuesday. Holder faces life in prison if he's convicted. Coming up on Law and Crime Daily, a police officer is charged in the death of Patrick Lyoya. Plus, hear opening statements from both sides as a Florida jury weighs a death penalty sentence against Alan Wade. Welcome back. An abrupt pause in the penalty phase in the resentencing trial of Alan Wade is bookended with opening statements from the prosecution and defense. The sentencing phase is now underway for Alan Wade, who was previously convicted in the deaths of Reggie and Carol Sumner. Wade, along with Michael James Jackson, Tiffany Cole, and Bruce Nixon, were convicted more than a decade ago for their involvement in the murder. Prosecutors argued at the defendants' trials that the 4 dug a hole in a remote wooded spot in Georgia before kidnapping the Sumners. The group stole from the couple's home, then forced them into the trunk of their own car. They later forced the couple to share their bank account information before burying them alive. Wade and Jackson will be resentenced separately after a change in Florida law which requires a unanimous jury decision for the death penalty. Last Thursday, prosecutors presented opening statements.
The state of Florida is presenting this case to each and every one of you because some evil acts are just too great to tolerate. Some evil acts can only be sufficiently punished by the ultimate punishment of death. In this trial, this week and next, each and every one of you will bear witness to the heinous, atrocious, and cruel evil acts that human beings are capable of.
After opening statements, the state called Wade's co-defendant Bruce Nixon. While Nixon was expected to testify on behalf of the prosecution, he testified he wanted to, quote, tell the truth when called. Nixon, who originally took the plea deal and did not receive the death penalty, could now face that sentence after violating terms of the original plea deal. When the judge ruled that both sides could not question Nixon, defense attorneys called for the judge to recuse himself, saying he inserted himself into the trial. After the very confrontational moment, defense attorneys threatened to call Nixon as their witness. After that, court took a recess until Monday. On Monday, Nixon returned to court with an attorney and pled the Fifth. Later that day, the state rested its case and defense attorneys presented their opening statement.
He will spend the rest of his days in a concrete cage, and he will be carried out of the Department of Corrections in a concrete box. He will leave in a casket. The only question that remains now is whether he dies of natural causes or whether it's of lethal injection. At the end of this trial, you're going to vote on whether a man, a human being, Alan Lindell Wade, whether he lives or whether he dies. And while some crimes do deserve the death penalty, some defendants do not. This is one decision that you will live with for the rest of your lives, and I'm going to suggest to you that you will never, ever regret choosing life.
All right, Terry, so Nixon pleads the fifth in Wade's resentencing after an absolute breakdown the first time, but you can't unring that bell. The jury heard it. So how do you think it will affect them in their decision making?
Well, you know, I think you're absolutely right, Brian. Once a jury hears something, it is very hard to disregard. And Judge Weatherby said, listen, don't draw any conclusions, disregard the testimony, but that's almost impossible. The jury is going to be wondering, what was he thinking? What was he going to say? What was the truth? Is the truth what he said before? Now, the good news is the judge did allow the prosecution to read into the record his former testimony. So he did testify in the record about the fact that Alan Wade was not forced to commit this crime. But we'll see what the jury is thinking, because it could be a little bit confusing to them to hear these, conflicting stories from this individual.
Yeah. Now, Janine, how was the defense opening, considering potentially their strongest witness pled the fifth, and how will that change your arguments going further?
I actually don't think it's going to, because again, the prosecution was able to read into evidence Nixon's testimony. And here's the thing: despite what happened, and it was an absolute circus, he testified prior that they'd gotten through the duct tape in the trunk of the car. They were hugging. It's just a really, really heinous situation. And when the defense says, some crimes deserve the death penalty, but some defendants do not, I really don't know how you can reconcile what he did with that statement. I just don't see it. And I think the jury is not going to see it.
I would tend to agree there as well. We'll see what the jury decides in this resentencing of Alan Wade. Again, Florida changes their laws when it comes to the death penalty, and that's why we're redoing this again. When we come back, a Michigan officer is charged in the death of Patrick Lyoya. Still ahead, what plea he entered. Welcome back. 2 months after 26-year-old black man Patrick Lyoya was shot and killed during a traffic stop, the Grand Rapids, Michigan officer who pulled him over is charged with murder. Officer Christopher Shue is now charged with second-degree murder. The officer pulled Lyoya over the morning of April 4th for an unregistered license plate. When Lyoya got out of the car, he and the officer struggled and fought across several front lawns. Lyoya was shot in the back of the head, which was caught on camera. The officer was placed on administrative leave pending the investigation and stripped of his police powers. Shue pleaded not guilty on Friday and was released on a $100,000 bond with conditions. Prominent civil rights attorney Ben Crump is representing Lyoya's family. All right, Janine, Christopher Shue's lawyer said the shooting was justified, but he was on top of Lyoya and shot him in the back of the head. Even if he had his taser, could that still be justified?
Well, here's the thing. I'm waiting to see what evidence this attorney can put in, okay? Because he talks about it was fired twice and it could be in a certain kind of mode. Again, he was shot in the back of the head. The officer was on top of him, and it's a tragedy. Mr. Lyoya was 26 years old. But again, he did resist arrest. He did fight. He did grab the taser. So it's really going to be about what evidence they can put forth to show that this police officer really felt that they were in danger for their life and that they had to use deadly force.
All right, yeah, plenty of video you can see there from close up and from a distance. Terry, Shue's attorney said he did everything according to department policy. So it makes me think, is this about a bad cop or bad police policy?
Well, let me tell you something. I have read the Grand Rapids Police Department use of force policy. This police officer absolutely, positively did not follow that policy. Basically, you're supposed to de-escalate, and you use the level of force based on the level of resistance. And so if it's a passive resistance, or even if it's active and he runs away, he did not have to respond the way he did. And so one of the things that these police officers have to be trained to do is not to escalate the situation. He could have let him go. He had the car. There was no reason to chase him down. There was no reason to take out that taser and have it be in a position where it could be taken from you. And this is what the policy states. It says all of these things. You don't have to use deadly force. You don't have to get yourself in that type of position. So I think this is a situation where the police officer could have done other things. He could have given verbal directions. He could have used physical control without using that taser. But at the end of the day, he put himself in that position. And it could very well be he had to use deadly force at that point, but he didn't follow the policy.
All right, we're going to find out a lot more about this case and the Grand Rapids Police Department's use of force policy. Thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.